In prior chapters, we discussed the nature of contracts and the 4 elements or requirements necessary for the formation of a valid contract. We identified and discussed the defenses available for contract enforceability. In this chapter, we'll discuss breach of contract and the available remedies in the event of a breach of contract. In tort law, we saw that damages compensate for the harm suffered as a result of another's wrongful act. Under contract law, by comparison, damages compensate the non-breaching party for the loss of the bargain. Innocent parties are placed in a position they would have occupied had the contract been fully performed. Exhibit 15-2 summarizes the remedies available to a non-breaching party. We'll discuss these remedies in detail throughout the remainder of the presentation. I would like to bring your attention to the box on the left-hand part of the slide. Punitive damages are rare. Under contract law, essentially they are generally unavailable to a non-breaching party. Compare this to tort law, in which punitive damages may be available to punish and to deter wrongdoing. That is unlike contract law, in which, again, punitive damages may not be available. Compensatory and consequential damages are available to a non-breaching party. Compensatory damages cover the direct losses and costs of the non-breaching party. Consequential damages cover the indirect and foreseeable losses of the non-breaching party. As mentioned previously, punitive damages, which generally punish and deter wrongdoing, are rare in contract law cases. Equitable remedies available to a non-breaching party include rescission and restitution. Rescission is an action to undo or to cancel a contract to place the parties in the position they would have been in had the breach not occurred. Essentially, the court will rescind the contract to undo the contract. Rescission is generally available as a remedy with claims of fraud, mistake, duress, undue influence, and lack of capacity. Restitution is an equitable remedy under which a party to the contract is restored to his or her original position prior to the loss or injury. The party to the contract is placed in the position he or she would have been had the breach not occurred. It may be that goods, property, or other funds subject to the contract have been conveyed, and under the restitution remedy, both parties will be required to return the goods or property or the funds that have been previously conveyed. In doing so, the parties will be placed in the position they would have been in had the breach not occurred. Specific performance is an equitable remedy in which a court orders the parties to execute the contract. This remedy normally is granted only when the legal remedy or monetary damages is inadequate to compensate the parties. Specific performance is generally only available when the subject of the contract are goods that are unique or custom, rare paintings or books, art, land, real property, for example, are goods that are considered unique, and therefore some other type of monetary damage is inadequate to compensate the parties. Under these circumstances, when these are the subject of the contract, a court may grant specific performance and order the parties to execute or perform the contract. Reformation is an equitable remedy used when the parties have imperfectly expressed their agreement in writing. There may be a dispute because Either a particular term has been left out or there's a disagreement about a particular term. Under reformation, the contract rewrites the contract or fills in the gap to ensure that both parties' true intentions are reflected in the writing. Reformation is common as an equitable remedy with covenants not to compete. The area and time restrictions must be reasonable, and perhaps the covenants not to compete in the original draft of the agreement are not reflective of what the parties intended. And therefore the court may reform the covenant not to compete to include reasonable area and time restrictions.